Well, that's the openings of the two parties. We now move on to the evidence, and we would start with the evidence of the claimant. Now, normally, of course, the tribunal will have the witness statements of the witnesses in front of them that will set out the evidence they wish to give. You don't have the advantage of that. So normally, the barrister in Mr. Pitlage's position would simply show the statement to the witness and ask him if it is true, and ask him if there are any changes he wishes to make to it. Exceptionally, this afternoon, Mr. Pitlage will guide the witness through, or take him through the evidence so that you can hear for yourself what would have been written in a witness statement. So on that basis, if we move forward, I would remind Mr. Pitlage and also Mr. Lauro that we have a one-day hearing only here today, and so there is a need to try and keep things moving as swiftly as possible. But Mr. Pitlage, please proceed.
Thank you very much, sir. For reasons which you're aware of and everyone in this room is aware of, exceptionally, I'm going to take my witness evidence in chief briefly. I call Mr. Triphyllis. I've promised Mr. Triphyllis not to ask him all the key details about place of birth, passport details, and date of birth as well. Mr. Triphyllis, I want to take your evidence. The central point is the agreement. There will be some ancillary points I will talk to you about: the vessel's condition, the ballast voyage, and cleaning options in Paranagua. But in the light of what Mr. Lauro has said for the charterers, the most important point that will be resolved by evidence is the agreement. So, in outline, please, tell me how you came to speak to Mr. Rondinella about the Singapore, what we call the Singapore hull cleaning agreement.
First of all, Mr. Rondinella works for a company with whom we have rarely had any problems before. Maybe it's the market pressure that is causing this kind of unusual behavior. But we talk often with his officers because we've done other business together. And really, we were surprised by the, what I say, arbitrary deduction of hire before Singapore. So I called up my colleague, and it seems that they had already informed our operation department they wanted us to be very speedy in the next voyage. So I said, how can you be asking something from us and at the same time, you know, be penalizing us for something? It didn't seem to make any sense to me. And, you know, I think Mr. Rondinella understood that it was an unsensible situation. So, in essence, we agreed that we'd pull over in Singapore and get the vessel cleaned, because obviously we're talking about a new building. There is no other reasonable explanation for underperformance except for the fouling. And we all know if you stay in tropical waters for longer than 20-25 days, there's a huge difference in the amount of growth you get on the hull. You know, I know the council said 30, 40, whatever, but it's not like that. The first 15, 20 days, it's just the way that organisms in the sea work. I mean, there's not enough volume to the growth. After a certain time, it's more problematic.
Sure. So let's get to the guts of the agreement. Yeah. What was agreed in this call between you and Mr. Rondinella?
It's very simple. We agreed to pull into Singapore, to clean her up, so that she can perform as they wanted in order to make the next port before the cancelling date. Pretty straightforward, really.
What exactly was Mr. Rondinella giving you or giving up to achieve this benefit?
I think, well, if you want to call it giving up, you can say he was giving up the 30,000 for the hull cleaning, and any kind of time the vessel would not be at the service of the charterer's commercial business. But I wouldn't say he's giving up. I'd say he's making sure he doesn't get cancelled the next time.
Did you discuss the claim that he had already effected for the Paranagua-China voyage?
Look, I went to a conference recently, sorry about this. I went to a conference recently and there was a discussion about an oil rig or about a vessel going under, and the captain stayed on board and was later penalized. And the person in the presentation said, can you imagine how wrong it is to penalize someone for doing his job well? So, you know, we are working for the charterers here and we are getting penalized. We stayed in Paranagua for them, longer than would have been needed to perform the business, and of course fouling occurred, and then we're responsible for this. That doesn't make sense to me.
What did Mr. Rondinella say to you about that point, about the responsibility for the delay from Paranagua to China?
I think he clearly accepted this was a fact of the fouling in tropical waters. No one in this business can deny this.
Okay, good. When you were at Paranagua, was it an option for you practically to clean the vessel?
If it was, we would have done it.
Okay.
You know how. You need to go somewhere reliable, clean water, visibility. There are a lot of parameters.
Right. In your experience, as an experienced ship operator, chartering on essentially global dry bulk terms,
Correct.
do you commonly find yourself waiting for 40 days without explanation?
No. Time is money. You cannot spend money without an explanation. Whenever we have waited, it's because there are others before us. There are problems with the queue. Maybe there is something with the cargo operation, you know, the elevator, maybe non-availability. But this mysterious waiting with no explanation, unheard of.
Was there any problem, back to Paranagua. Did you try to elicit from Mr. Rondinella reasons for the delay at Paranagua?
Well, I mean...
Did he give you any explanations?
Not anything that was, you know, a complete explanation. He would start in one direction, then finish on some other. To be honest, I was confused, but I didn't care because I got what I wanted, which was for the ship to be cleaned at the charterer's time to perform well.
Just so I understand, I'm talking now, when you sailed to and were stuck waiting for those long 40 days in Paranagua, were you seeking explanations for that delay, and were you getting clear explanations?
Well, I think that not from the beginning, because a delay up to 15 days, as we said, is customary in a lot of cargo operations. But I would say moving into between the second and third week, the crew and the captain started having their own issues. So of course we wanted to hear what's going on. Maybe we need some fresh water. Maybe we need some extra food on board. Maybe we need to think about what to do next. So of course there are a number of exchanges.
But were you getting a clear explanation?
No, there's no clear explanation to today.
Fine. Last question. Were there any problems with the vessel prior to delivery? Could you discern any problems in particular with the hull fouling or propeller problems?
This is a new building vessel. It's under a year old. The last thing you are going to find is hull fouling. Even if they have not put the correct anti-fouling and they put even a sliver, it should do the job. There was some underperformance in a ballast leg from the shipyard, but I think this was more probably with learning how to do the trimming on the vessel or other teething issues you get with the new technology.
Sure. Thank you, Mr. Triphyllis. Mr. Lauro might have some questions for you.
So, thank you, Mr. Triphyllis. If my understanding is correct, you appear to support the charter's case.
I don't support any case. What I want is just what is fair. And this is for if you're doing something in somebody's service, not to be penalized for it. That's all I'm doing.
This is beautiful that I think your word of mouth comes before your interest, and I'm sure that charters appreciate.
Shipping's an honorable business.
No, because you're a very good counsel. He has tried in any way to make you to tell that there was something strange, instruction of the charter, and you said no, there were other vessels in front of us, so it took a bit longer, but as it happens in Paranagua. So, I mean, this is not the main subject that I'm interested to know you, but would you allow me to congratulate with you if the tribunal allows me to?
In all fairness, I don't deserve this congratulation because it's clear you've misunderstood what I was saying.
Oh, yes, I may have.
So I don't want to take, kudos for something I have not done. And in this case, all I said was that it can be typical to have a delay up to 15 days. It's quite different beyond that. So I think maybe you misunderstood something, or maybe, and it's strange because you're here where you can hear well now. So maybe you need to go to the next level.
Sorry, perhaps I'm becoming old, but
no.
I want to stay in the profession for the next 30 years. If so you have to accustom, in particular the tribunal, to... No, this hasn't got to do with the length. We already said that this length is not very usual, but it happens in this type of ports. But this is legal, it's not an evidence from you. You said that there was nothing abnormal, there were just other vessels before yours, and I'm satisfied by this, and I find you're saying this very beautiful. Just this. Now, let's go to the core of your witnessing. You said that, in fact, you had this conversation and everything was very normal, and obviously, if the vessel had to perform better, it should have been cleaned. The fouling was heavy, and obviously, you had a 1-year time charter. So, I don't want to imagine what would have happened if you never took this step of the dry dock, because I think, can you imagine what would have been the speed at the end of this 1-year time charter? So your decision was very sensible, and I think the charters who are also owners, or have been owners in the past...
Is this a question?
Yes, did not have to
Get
object.
to the point, Mr. Lara.
The question is, let's go to the point. Have you discussed any, franchise period, or any, let's say, paid off-hire from the service, of period that the vessel was not on service, for which it would have been earned higher with the charter? This is the point, and obviously the cost of this. And in which terms?
I'm sorry, I don't understand exactly the question.
So you said we have to do this dry dock. The charters did not oppose; they were happy.
Okay.
But there was. You say also that there was an agreement.
Okay, I understand the question.
What was the agreement? How did you negotiate this agreement?
Well, I negotiated over the phone in good faith and goodwill with a long-time business counterparty. But the essence of the agreement was to make sure that we would not be pulling into Singapore for other reasons. That maybe we were trying to do something for our own account and hiding behind this fouling issue to do it. So, from my part, the undertaking was that we would not be doing anything else except for the fouling. And the second part was that I gave them an option that if they're willing to tolerate this slight underperformance, we don't have to pull into Singapore, but there might be a chance we would miss the Lake Hand days for the next trip. So this is, I think, the crux is that it seems the next voyage was quite valuable. If they missed the date, they would not do it. So they were more than willing to give us the necessary, day and a half, whatever it is, between the deviation and the underwater diving to take care of the business. This was the essence of the agreement. The cost of deviation, the cost of the divers, that's it.
And did you negotiate the cost? Did you say you'll pay in full for the time, for the cost? Did the charter propose you to share this cost?
Well, I'm surprised Mr. Rondinella hasn't clarified this to you, but basically the discussion was in the terms that any cost pertaining solely to the underwater cleaning and to the deviation needed to perform it would be for the charter's account.
So they didn't say, I'm not saying that they said
we
this.
know more or less the figures.
They did not say, let's share this.
No, but no, we never agreed to share it. No.
They gave it to you for free.
It's not for free. They gave it to protect the next charter and to avoid any further disagreement on underperformance.
Disagreement?
Yeah.
Because there was a disagreement.
Well, I would say that if they choose to withdraw payment of hire, this is a different view from what the charter would normally dictate.
Okay. So they had the claim, they waived the claim, and they gave you free time and paid for the cost to put your vessel in contractual condition, your one-year time charter vessel?
That's how long-term counterparties behave when there is a common cause. And the common cause at that moment was to make the lake can for the next trip.
And I congratulate, because you are a great negotiator. I consider myself not a bad negotiator, but I couldn't have done this. After having, this is the last question. This is the last question. After having obtained this extraordinary result, did you put this in writing, even though in a casual way, without an amendment to the time chart saying what we have?
Look, I may have scribbled something on a note, but not something that I would put in a record or
I mean on an email. When I say put in writing, I mean a message.
Look, in this business, our words
The email are not used in the shipping
Mr.
business,
Rondinella,
right?
We've agreed thousands of things over the telephone. And you know, really, no offense, but we can't bring a lawyer and a legal document every time we talk on the phone with a counterparty. Didn't you hear what the chairman of Shell said 100 years ago?
Okay, if you are happy with this, perhaps it's better you wait the award and you decide if you want to continue like this or you have to take different steps. But thank you very much for answering my questions.
Thank you.
I will now ask my co-arbitrators if they have any questions that they would like to put to Mr. Triphyllis arising out of that.
Yes, I have one question. Mr. Triphyllis, could you go over again why you didn't follow up the conversation in writing, just as to be polite or to make sure that there was no misunderstanding? It's frequently the case that an agreement is confirmed in writing in one way or another.
You are probably right that in many cases one might follow this type of thing up. However, because of the long-standing relation with the counterparty and having done a lot of business, perhaps we were a bit more comfortable that as long as we had the verbal assurances of, the Honorable Mr. Rondinella, it would not be needed to be put in writing, and maybe also just the pressure of time, that moment, that didn't allow me to follow up as soon as I wanted. By the time I got round to thinking about it, this had already taken place. I mean, what's the point putting something in writing after the fact?
I have just one question. I'm not certain to whom I should address it, but I suspect that it's Mr. Triphyllis or Mr. Pitlarge, because they are the claimants in the arbitration, and it's for them to make good their case. And that is, and the otherwise admirably clear summary of the facts that we have here, and it's probably just the fact that, for reasons that some of you can probably understand, that I'm suffering from the effects of rather too late and good an evening last night. But it's not clear to me whether the deviation from the voyage for the hull cleaning at Singapore took place on a ballast or a laden voyage. And the reason I raise it is that that could be significant, because if there was cargo on board and bill of lading contracts had been issued, a deviation could be a breach of the bill of lading contracts, which would mean that it would be even less easy to understand why an agreement of this kind had not been put into writing. So I don't know if anyone can help me with that.
No, obviously it's a ballast leg, and this is obvious because we were making utmost haste to make the time to receive cargo on the next voyage. And this is this pressure on the time, which put a lot of pressure on us at this time of the market, is exactly why we try to think of any way possible to get things done quickly.
Thank you, Mr. Triphyllis. Let us now move on to the Charter's evidence, and I understand, Mr. Lauro, that you wish to present the evidence of Mr. Rondinella.
So, Mr. Rondinella, try to be shorter with you. Before asking you if you reached any agreement with Mr. Triphyllis, well, first I will ask you if did you have a conversation with Mr. Triphyllis at that time?
Yes, sure. We confirm we have a very open-minded discussion with the owner on the 7th of June last. And I regret to...
Do you mind to reply just to my question, so perhaps we can...
Yes,
proceed?
yes, please.
Before asking you if it was agreed anything during that open-minded conversation, may I ask you if at that time you knew you have been a shipping man for decades, if you knew that it was owner's obligation to remove the fouling and to perform under the charter, or you perhaps were in doubt about this?
No, at that time we were not aware of the amount of the underperformance. We were aware that the vessel underperformed, but we had no plan for the cleaning, neither an agreement for that.
But perhaps I was not clear enough. Did you know that it was the owner's job to fix this problem and was not the charter's job?
According to the terms of the time charter contract, my answer is yes, because there was no specific hull cleaning clause, like, for example, BIMCO clause.
So you were aware of the position. And was there an agreement between you and the owners that you would have sustained the time or part of the time or the cost, of the cleaning?
Absolutely no.
So
the terms of the conversation were mainly related to the deviation and the instruction that the vessel received to divert to Singapore for cleaning.
So perhaps the owners thought in good faith that you didn't oppose.
Yes, maybe, yes.
And you, in good faith, didn't oppose.
Yes.
Okay, for me it's enough.
Mr. Pitlarge.
Mr. Rondinella.
Yes,
good
please.
afternoon. Several questions on your evidence, please. I'm slightly unclear as to why you think that the owners were obliged to clean the hull. You say in your answer to Mr. Lauro, there was no hull fouling clause like you see in the BIMCO form, therefore the owner was bound to clean the hull. Given there was no written term, how did you come to reach that conclusion? And did you express that view to Mr. Triphyllis?
We are managers, operation managers of many vessels. So we are aware that in many cases the vessel will wait for some days before loading or off, before discharging operation. In our opinion, this is a duty of maintenance of the owner to have the vessel prepared for such a case. That, on the other hand, you should learn that there are some advantages for the owner having the vessel in a idle situation. This is undisputable that there are some savings for that. This is in a normal discussion on the commercial terms, but this is why there are specific agreements for hull cleaning clause that in this case were not included in the contract.
Let me just understand your position on that. You have a specific agreement dealing with hull fouling because the position is unclear otherwise. Is that what you're saying?
I don't think he said this. Huh? I think if we have a tape, we can hear it again.
I think the evidence is that of Mr. Rondinella, with all due respect, Mr. Lauro.
I suspect, with all due respect to the tribunal, that we should ask the witness about question of facts. If we want to ask question of law, we should take other expert witness of law.
Mr. Lauro, with all due respect, we will have the transcript available. We can see what Mr. Rondinella said, but I'm allowed to ask him questions on what he's just said. He has said that you put in a specific clause to clarify matters. The obvious relative proposition to that is that it's otherwise unclear, and I just want him to accept that.
With all due respect, I think we are a bit putting words.
Let Mr. Rondinella answer that question, and then we can move on.
I repeat that I don't want to enter into legal aspects of the time charter contract, but what I can confirm that according to the terms of the contract in place, there is no provision for hull cleaning operation or cleaning clause at all. So in a situation where the vessel was at that time, there is no ground for us to consider such a burden on charterer account.
I see. Just to close on that point, you reached that conclusion. Can we summarize it thus? That on your understanding of the terms without the hull fouling clause, sometimes yes, sometimes no, for the obligation for the owners to clean the hull. Is that a fair summary of your view?
Sorry, I object.
Mr. Lauro,
in my opinion,
Lauro,
if you make a question of law to a witness who is not a lawyer, the question should be more precise. The witness, sorry if I may, he has already said that in absence of the clause, he believes that this is the owner's obligation. Then if we want to put it in a smart way in order to make him wonder about this, probably both you and I could be able with the respective witnesses. I don't know if we succeed. Mr. Rondinella was not saying this. So please, if you want to put the question, put a very detailed question.
I think we have the record of what Mr. Rondinella has said, so shall we move on, Mr. Pitlarge?
Mr. Rondinella, the agreement, you had this discussion, and did you object to the vessel? Did Mr. Triphyllis make it clear to you that on the basis of what you agreed with him, the vessel would sail to Singapore?
The agreement to divert the vessel to Singapore was only related to the operation aspect of the vessel that needed to be fixed for a subsequent voyage. I can confirm that it was a wise decision because we had at that time no objection to do that. Said I can confirm that I replied to the owner that from our point of view we have no objection at all, but it is not an assumption of a liability for covering the cost and expenses for this deviation.
So let me understand, you have no objection to sailing to Singapore. The deviation to Singapore is, in your own words, for your benefit to meet your next commitment, your benefit. So why do you not feel that at the very least you should be paying for that particular time?
There are many operations that can be done for the charter interest as well. For example, any maintenance job is for owners and charter advantages. This does not necessarily mean that we have to cover such a cost. In addition, I would like to emphasize that during the discussion, the owner never invited us to attend the inspection in Singapore because, as you know, in the hull cleaning clause, it is quite usual to invite the counterparty to have a joint inspection in order to check the amount of the fouling. This is a normal cross-check that can be made on occasion of the cleaning operation.
Because that was an operation for your benefit, you wanted to participate.
Yes, but the amount of the fouling is normally something that could be checked from both parties in order to decide the amount of the fouling, because it is quite clear that the fouling can have a different proportions. That means expanded, extended cleaning operation and so on.
So let me understand this. Your objection is to the fact, not that it was for your benefit, which you accept, but that you just couldn't participate by way of a joint survey. Is that right?
This is this was definitely a good operation, a good owner initiative. But this does not necessarily mean that we are part in the covering of the relevant costs.
So you deny that you were responsible for, despite all of these things, despite the discussion which you now accept took place with Mr. Triphyllis, despite the benefits that would have accrued to you and your employment of the vessel. You deny, firstly, that you agreed to cover the time, despite it being your orders to Singapore. Is that right?
That's correct.
And you deny the obligation to pay Mr. Triphyllis the costs.
Yes.
And what do you make of Mr. Triphyllis' clear statements that in this discussion, which took place against the backdrop of, let's call it, the Paranagua problem, that you acknowledged that it was really your fault for delaying the vessel at Paranagua? Mr. Triphyllis was clear on this at the end of his evidence. Do you agree with what he says or disagree?
The Paranagua delay is not an abnormal situation. This is quite usual to have a long time waiting outside the port before loading. I can agree that this situation was unfortunate for the owner, but I have nothing to add to that.
I see. And my last question, and thank you, Mr. Rondinella, when Mr. Triphyllis describes your coyness, your lack of being upfront about the reasons for the delay, it would be the easiest thing in the world to refer to congestion or loading problems, but you didn't. You didn't make any clear answers or statements according to Mr. Triphyllis and the master's statement, which is in evidence as well. Why did you not simply, what were the reasons for the delay at Paranagua, and why did you not explain them or send messages to that effect at the time?
The reason of delay was the port congestion that was unpredictable at that time. As a statistic, the normal waiting time in that port is in the range of some weeks. So I cannot say that 40 days maybe is exceeding a bit the normal average waiting time, but this is not a strange situation in Paranagua.
Thank you, Mr. Rondinella. I have no further questions.
So the tribunal does not have any questions, so thank you for your evidence, Mr. Rondinella.